Hey guys, someone recently reached out to me, and I encourage you to do the same. Any questions you've got, I'm trying to be an open book this year and share with you as much as I can. But someone asked me about buyer's remorse in a personal injury case. Got hurt in a restaurant over 3 years ago. Had an expert opinion of what the value of the case was, what they should get paid, and ultimately the mediator and her attorney advised on settling the case, and they got it done, and just she wasn't happy with the results, and just wondered kind of why that happens. And so just kind of wanted to briefly share some of my opinion on how that works and why that is. And it's a simple economic issue to me. So uh, if you think of it, really, when you get into a case where there's a contingency fee attached to it, that's where one person doesn't get paid unless something else happens. Then you've got an economic stake. And I think to avoid this kind of buyer's remorse, you've really got to look at it as a business deal. You are business partners. The client has the case, and what happened to them. It's personal to them, and they're the only ones who can bring a lawsuit or a claim against an insurance company. They've got the asset in the business deal. The lawyer has the skills and the equity possible to turn that asset into income. Uh, I know that's a little bit of a dry and impersonal way to think of it, but the economics of that reality is what I believe drives what the ultimate outcome will be. When you're thinking of it in that terms, then it makes a lot more sense. Uh, One side is putting in the money and the time and the resources to generate or work on this claim or this lawsuit, and the other side is the one who owns the rights to it. And so I think to avoid buyer's remorse, you've really got to have that outlook from the outset and have a candid relationship, candid conversations with each other about that relationship, about the risks you're taking on, about what you expect the outcome to be, and continue to have that open relationship, that open conversation as you go on. I think too often we as lawyers like to think that we know everything, or we've got all the answers, or there's some magic to what we're doing. There is skill involved, there is experience involved that the client likely doesn't have, and I think lawyers improve outcomes in these types of cases. But in order to have a satisfactory end or conclusion to the case, I think you've got to go into it with an open book, um, with eyes wide open as to what we're putting in and what we expect to get out. And so the typical setup is something happens to the client. They come to see the lawyer. They agree. Lawyer's going to pay for everything. And if they win, when they win, they're going to get 33%, 25%, 40%, whatever's fair. And you guys negotiate. Um, and then you're off to the races. So when you get down to it, if you're looking dollar for dollar, if we look at the old model of hourly billing, I've advised clients that all the pre-trial stuff, the stuff that happens before you ever get in a courtroom and go to trial, on just a standard case with nothing much complicated happening, you're probably looking at spending between five, ten, $15,000 just to get to that point, and there's a high likelihood of settlement somewhere in there. And if you need to go to trial, if there's just one party just is not willing to negotiate, or you just can't meet on what's a fair outcome, then the trial itself will probably double that expense. So you probably spend another $15,000 to $20,000 just on time and expense in getting that done. And then at the end of the day, it's up to a judge or jury as to whether you win or lose. You may get zero, you may get the moon. So when you're between those two and you're in mediation and you're at the negotiation table and you have a sure thing, someone saying, I will pay you whatever it is, $15,000, $40,000. You may have the information that experts told you that at trial you might expect to get, $100,000, whatever it is. The hard and fast reality is that you are faced then with not a decision about justice or a decision about what's right or wrong as far as it relates to what happened to you, but you're faced with an economic decision, and you've got to realize that the person in the room with you has a stake in that economic decision. They've got a stake in that business outcome. And so just using business judgment, you've got to evaluate then, does it make business sense to spend the money it's going to take to put on a trial and get possibly that marginal amount more in return for this case, or does it make better business sense to recapture the costs that we've already spent and the profits we'd get from this settlement and move on with our lives? So it's the basic thing. If you have economics, 101, just the marginal risk and the marginal return. We've got a sure thing on the table now. We can take this money. We'll be done with the case. We'll be done with the stress. We'll be done with expenses. We will avoid the costs of trial. It may not, in fact, it will not be the outcome you want. It will not be the outcome you think is fair, but it will be done. And you have a sure amount of money. The other side of that coin is there's some marginal risk. You may think you've got a sure thing. Your lawyer may think you've got an 80% chance, and you may have the chance to capture some more revenue, to capture a different outcome if you take it to trial. But you've got to look at it from the point of the risk that you're putting in, the money that your partner lawyer is putting in, and decide if that's for you. So that leaves you kind of with a bad taste in your mouth. You didn't get what you think was worth. You feel like you were treated unfairly. You feel like they should have to pay more. They should hurt more. But I think when you put on the glasses and view it from the point of view of running this as a business, and you do that from the outset and have the hard conversations throughout the process, then you can come away with a better feeling and a better outcome. That also raises the questions of how can we change that model? Is that the best we can do? And I think that just comes from conversations. So maybe it is, but maybe it's a scenario where you can afford, as the client, to pay the expenses. You can afford to fund the litigation. And in that case, keep more of the profits or the outcome of the case. So I think you just have to have those candid conversations with your attorney, candid conversations with your family, figure out what you can do, really value what the other person is bringing to the table. And flipping that script, lawyers really need to value what the client's bringing to the table. You're the one that can give them access to the courtroom or to the insurance company in a fair way, but they're also generating revenue for you by bringing an asset to the table in the form of their claim. So I think the conversation needs to change. The power dynamics need to change between the attorneys and the clients. And if we take the time to do that and have those hard conversations, candid conversations, I think we end up with better relationships, better outcomes, and most importantly, I think better feeling about the outcome. So I hope that this gives you a little insight into a little bit of the struggle that goes on the ground as it relates to those types of claims. We're going to be talking to an experienced personal injury lawyer who does nothing but personal injury day in and day out, either on audio or video in the next couple of weeks. So be on the lookout for that. I'm excited to talk to him. If you got any other questions in this area before I get to talk to him, be sure to let me know. I'll put those questions to him, and we'll continue to bring you everything we can. Again, any questions in any area of legal issues or law practice, shoot them to me. I'll track them down, and we'll see what we can find out. Thanks, guys.